BNS Bharatiya Nyaya Sanhita, Chapter 1 Preliminary, Section 3 General Explanations. Throughout is subsection first. Throughout this Sanhita, every definition of an offence, every penal provision, and every illustration of every such definition or penal provision shall be understood subject to the exception contained in the chapter entitled General Exceptions, though those exceptions are not repeated in such definition, penal provision, or illustrations. So simplified इसमें क्या है in this law जो every definition of a crime, every punishment rule and every example should be understood with general exception in mind, even if those exceptions are not mentioned again in each case. So illustrations of this subsection 1 with example A is the section in this Sanhita which contain definition of offences do not express that a child under 7 years of age cannot commit such offences, but the definition are to be understood subject to the general exception which provide that nothing shall be an offence which is done by a child under 7 years of age. So this means that the defined crimes do not say that a child under 7 cannot commit these crime, but it is understood that a child under 7 cannot be guilty of a crime. Let's take a second example. A police officer without warrant apprehend Z who has committed murder. Here A is not guilty of the offence of wrongful confinement, for he was bound by law to apprehend Z, and therefore the case falls within the general exception which provide that nothing is an offence which is done by a person who is bound by law to do it. So in this example, a police officer A arrests Z without a warrant for committing murder is not guilty of wrongful confinement because he is required by law to arrest Z. So this falls under the general exceptions. Now we talk about subsection second. Every expression which is explained in in any part of this Sanhita is used in every part of this Sanhita in conformity with the explanation. So this means every term explained in any part of this law is used the same way throughout the entire law. Now let's talk about subsection 3. When property is in the possession of a person, spouse, clerk or servant on account of that person, it is in that person possessions within the meaning of this Sanhita. So this subsection third means if property is held by someone spouse, clerk or servant on behalf of that person, it is considered to be in that person possessions. Now we talk about subsection 4. In every part of the Sanhita except where a contrary intention appears from the context, words which refer to act done extend also to illegal omissions. So this subsection 4 means that this legal concept as stated in IPAC section 32 means that when the law uses words referring to actions, it also applies to illegal omissions, failures to act, unless the context clearly indicates otherwise. In simpler terms, if a law prohibits a certain act, it also prohibits failing to do something when there's a legal duty to do it. Example act. The law prohibits stealing a car. Omission: a person sees a thief stealing a car but does not nothing to stop it, even though they have a legal duty to assist. This omission would also be considered a violation of the law, similar if they had directly stolen the car. In essence, the law considers an illegal omission as a type of action if the context does not suggest otherwise. So let's take section 5. When a criminal act is done by several persons in furtherance of the common intention of all, each of such person is liable for that act in the same manner as if it were done by him alone. So, so section 34 of the IPC also state that when a criminal act is done by several people in furtherance of a common intention, each of them is liable for the act if they did it alone. This means that all participants share the same criminal intentions and are held accountable for the actions of the group. Examples: imagine three friends A, B, and C decide to rob a bank. They all agree on this plan beforehand, and B and C enter the bank while A waits outside. A then realizes his friends are being caught and runs away. B and C are caught. Under under this subsection, even though A did not physically enter the bank, he is still liable for the robbery because the act was done in furtherance of their common intention. So, key concept is common intention, furtherance, or joint liability. Common intention is shared, pre-arranged plan among multiple individuals to commit a crime. Furtherance: the act must be done in furtherance of the common intention, meaning it directly contribute to the achievement of the shared goal. Joint liability: each person is liable for the consequence of the act as if they had done it themselves, regardless who physically performed the act. Now we talk about subsection 6. This is also same meaning. Whenever an act which is criminal only by reason of its being done with a criminal knowledge or intention is done by several persons, each of such persons who joins in the act with such knowledge or intention is liable for the act in the same manner as if the act were done by him alone with the knowledge or intention. This act was in IPC section 35. So this means it deals with the concept of joint liability for criminal acts. It states that when an act is done by several persons, each with a criminal intention or knowledge, every one of those persons is equally liable for that act. This section is vital because it emphasizes the collective responsibility of individuals involved in a crime, even if their roles in the act differ. In simpler terms, if multiple people are involved in committing a criminal act and have knowledge or intent regarding that act, they all are considered equally guilty, irrespective of their role they played. This section is crucial when dealing with cases involving group activities where proving individual intent or action can sometimes be challenging. So let's talk about subsection 7. Wherever the causing of a certain effect or an attempt to cause that effect by an act or by an omission is an offense, it is to be understood that the causing of that effect partially by an act and partially by an of omission is the same offense. This subsection was in section 36 of the IBC. State that if causing a specific effect or attempting to cause it through an act or omission is a crime, then causing that effect partially by an act and partially by an omission is also considered the same offense. In essence, it clarifies that a combination of both actions and inactions can still result in the same criminal liability. Simplified, imagine a situation where someone's actions and inaction both contribute to a harmful outcome instead of being two separate offenses. Example: if a person causes someone death by both beating them and failing to provide necessary medical care. The combined act and omission are still considered the same crime of murder, even though they use different methods to achieve the same outcome. Let's take a second example. A intentionally causing Jed's death, partially by illegally omitting to give Jed food and partially by beating Jed. A has committed murder. Now talk about subsection 8. When an offense is committed by means of several acts, whoever intentionally cooperates in the commission of that offense by doing any one of those acts, either singly or jointly with any other person, commits that offense. So, this subsection was in section 37 of the IPC. Addresses joint liability when an offense is committed through multiple acts. It states that if an offense is committed by several actions, anyone who intentionally participates in that offense by performing one of those actions, either alone or with others, is also liable for the offense. Simplified explanation: imagine a robbery where several people are involved. One person might be responsible for breaking into the store, while another might be holding the employees at gunpoint, and a third might be stealing the merchandise. If any one of these individuals actively participated in the robbery by performing any of these acts, they would be considered guilty of the entire offense, even if they did not perform of perform all the acts. This is because they intentionally cooperated in the commission of the offense by doing one of the necessary acts. If, in essence, if you intentionally help someone commit an offense by performing an act that is part of the offense, you are also liable for the entire offense, regardless of the role you played. So, key concepts: joint liability, intentional cooperation, one of several acts, singly or jointly. These are the main concepts of the subsection 8. Let's take an example. A and B agree to murder Z by severally and different times, giving him small doses of poison. A and B administer the poison according to the agreement with intent to murder Z. Z dies from the effects of the several doses of poison so administered to him. Here A and B intentionally cooperate in the commission of murder, and as each of them does an act by which the death is caused, they are both guilty of the offense, though their acts are separate. Let's take second example. B. A and B are joint jailers, as such have the charge of Z, a prisoner, alternatively for 6 hours at a time. A and B, intending to cause Z's death, knowingly cooperate in causing that effect by illegally omitting each during the time of his attendance to furnish Jed with food supplied to them for that purpose. Jed dies of hunger. Both A and B are guilty of the murder of Jed. Let's take third example. C. A jailer, has the charge of Jed, a prisoner. A, intending to cause Jed's death, illegally omits to supply Jed with food, in consequence of which Jed is much reduced in strength, but the starvation is not sufficient to cause his death. A is dismissed from his office and B succeed him. B. Without collusion or cooperation with A, illegally omits to supply Z with food, knowing that he is likely thereby to cause Z's death. Z dies of hunger. B is guilty of murder. But as A did not cooperate with B, A is guilty only of an attempt to commit murder. Now, last subsection 9, where several persons are engaged or concerned in the commission of a criminal act, they may be guilty of different offences by means of that act. This subsection was also included in subsection 38 of the IPC. When people participates in a criminal act, each of them can be held liable for different offences based on their individual roles and action. Illustration: A attacks Z under such circumstances of grave provocation that he is killing of Z would be only culpable homicide, not amounting to murder. B. Having ill will towards Z and intending to kill him, and not having been subject to the provocation, assist A in killing Z. Here, though A and B are both engaged in causing Z's death, B is guilty of murder and A is guilty only of culpable homicide. Simplified. Let's take a second example. Imagine a group of people robbing a bank. One person might be responsible for breaking the door, a separate crime, another for holding the hostages, another crime, and a third of stealing the money, the main offense. Each of them can be charged with the specific offenses they committed, even though they all participated in the same overall criminal act. So, key points: shared intent, individual liability are the key points of the subsection 9. So, this is all all part of section 3 BNS general exception. Subsection 9 include. So, thank you for watching the video and like and subscribe my channel Low by Jatin Bhatt.